Hi, I'm Marc, and on this channel I talk about Brexit and UK politics. Now, an appeal process began on Monday at the highest court in London following plans by the British government to send migrants permanently to Rwanda without examining an asylum application, and that would violate asylum law. The High Court had declared the action unlawful. The Conservative government had lodged an appeal against this, which will now be heard in the Supreme Court. It was initially unclear when a decision could be expected. It could be weeks or months, said a court spokesman to the German press agency. The plans of Great Britain's Home Secretary Suella Braverman envisage that people who have entered the UK, let's say irregularly, regardless of their origin and without examining their asylum applications, will be detained and deported to Rwanda as soon as possible. They should then apply for asylum there, and there are no plans at all to return them to Britain. There is a corresponding agreement with the government in Kigali, and which has been repeatedly criticized by civil rights activists for human rights violations. You might have seen my video where I did that as well. In June, a majority of judges at the High Court ruled that Rwanda could not be considered a safe third country. I agree. And the reason is deficiencies in the asylum procedure there. It cannot be ruled out that those seeking protection from Rwanda would be deported back to their home countries, even though they are entitled to asylum. The British government wants to use its Rwanda policy to deter migrants who enter the country irregularly in small boats across the English Channel. Last year, more than 45,000 people came to Britain this way. However, the European Court of Human Rights had stopped the only planned flight to Rwanda last summer with an interim injunction. The British asylum policy is currently at court because of those legal challenges from two charities, and that's Asylum Aid and the Refugee Council. The charities argue that the policy is unlawful because it discriminates against refugees who have arrived in the UK through irregular routes, such as by boat or lorry. They also argue that the policy is unfair because it does not take into account the individual circumstances of each refugee as it should be. The British government has defended its asylum policy, arguing that it is necessary to deter illegal immigration and to protect the UK's borders. The government has also argued that the policy is fair as it provides a pathway to asylum for those who are genuinely fleeing persecution, just not in Britain. The legal challenge to the British asylum policy was being heard by the High Court of England and Wales, and they issued a ruling about this. And as I said, and now they are appealing it. And the challenged British asylum policy violates international law in a number of ways. First, it violates the principle of non-refoulement, which prohibits states from returning refugees to a country where they are at risk of persecution. The policy does this by creating a two-tier asylum system in which refugees who arrive in the UK, even through irregular routes, are less likely to be granted asylum than those who arrive through regular routes. And this means that refugees who arrive in the UK through irregular routes are more likely to be returned to their home countries, even if they are at risk of persecution. Second, the British asylum policy violates the principle of family unity. This principle requires states to take steps to keep families together, including by granting asylum to family members of refugees. The British asylum policy, however, makes it difficult for refugees to bring their families to the UK. This is because the policy requires refugees to have a certain level of income and accommodation before they can bring their families to the UK. This requirement is difficult for many refugees to meet, as they are often struggling to make ends meet. And third, the British asylum policy violates the principle of equality and non-discrimination. This principle requires states to treat all refugees equally, regardless of how they arrived in the UK. The British asylum policy, however, discriminates against refugees who arrive in the UK through irregular routes. This is because these refugees are less likely to be granted asylum than those who arrive through regular routes. They are also less likely to be able to bring their families to the UK. In conclusion, the challenged British asylum policy violates international law in a number of ways, including by violating the principles of non-refoulement, family unity and equality, and non-discrimination. And that's why it's possible that the Court of Appeal will come to the same conclusion as the High Court of England and Wales, and they will rule that the British asylum policy like this is unlawful. If they find that the policy violates international law in a number of ways, they will definitely do the same. And no, it's the Supreme Court now that's on it. The names of the courts are sometimes it, but it will not change anything. If this appeal of the government now is rejected, the whole Rwanda plan is out of the window, as we would say. And so that is exactly what I'm expecting. I still have trust in jurisdiction. And there is nothing that would say that this is possible, because the British asylum law is based on law, and it has to comply with this law. And the courts and their rulings are based in this case on both British and international law. British law is the primary source of law for the courts. This includes the non-written constitution, statutes enacted by Parliament, and common law, which is judge-made law. But international law is also the source of law for the British courts. It's true, international law is only binding on the courts if it has been incorporated into domestic law by Parliament or by the courts themselves, which it is in this case. In the case of the British asylum policy, the courts will consider both British and international law when making their decisions. And the courts need to decide whether the policy is consistent with the Constitution, statutes enacted by Parliament, and common law. And the court will also need to decide whether the policy is consistent with international law, and there where I see the decision coming. If the court where the appeal is running finds that the British asylum policy is inconsistent with either British or international law, it has to declare the policy to be unlawful. And this new British law is violating international law, and so that is the decision that I do expect. And if you want to know something else about Brexit or British politics, the next video is right here in the end screen. I'll see you there. I'll be back.